Ladies and gentlemen, welcome to this short introduction to international divorce from a Swiss standpoint. When do Swiss courts have power of jurisdiction in divorce cases? Well, it depends on the domicile of the spouses. If one of the spouses is domiciled in Switzerland, then the court of his or her domicile is going to have power of jurisdiction. If one of the parties is Swiss and not domiciled in Switzerland, this party can also plead at the place of his or her origin. The divorce judge can also hand down interim relief orders on the effects of the marriage, that is, on the exclusive use of the matrimonial home and its furnishings, on the care of children in common and contact and maintenance, and in case of need, of course, this judge can order worldwide disclosure and also worldwide asset freezing. This judge will rule eventually at the end of proceedings on the effects of divorce. In Switzerland, the effects of divorce are the matrimonial regime, that is, its liquidation, the sharing of Swiss pension plans, and post-nuptial support, if any. You need to know that Swiss courts have exclusive power of jurisdiction on Swiss pension plans sharing. But those courts have no power of jurisdiction to hand down orders which relate to contracts. That is, contracts which are not related to the marriage. For example, on corporations, loans, work contracts, whatever. All those contracts that the spouses can execute with one another, which is going to be also an access to transactions. We will revert to that later on. Swiss courts also have power of jurisdiction to hand down orders in support of proceedings which are being pleaded abroad. For example, on disclosure, asset freezing, and that could be related to the effects of a marriage or to divorce proceedings. And of course, Swiss courts will provide international legal assistance to foreign courts. For example, this is very often the case for discovery. Swiss courts have also power of jurisdiction, of course, to enforce foreign judgments. And if those judgments have ordered interim relief measures, one hesitates all the time to have them enforced or to ask for mirror orders. It depends on the orders that have been handed down. Enforcement proceedings can also relate to disclosure, to asset recovery, or to maintenance, and of course, to the return of abducted children based on international treaties. Now, when in Switzerland do you have a lis pendens? It's very, very important to understand that in Switzerland, it's the court first sees that retains its power of jurisdiction. And that is irrespective of different choices of court, which can create a problem in European context. But if the parties ask the court to relinquish its power of jurisdiction because they agree to submit their matrimonial regime to another court, then a court might consider to allow them to plead somewhere else that specific question. The court first seized will retain its power of jurisdiction irrespective of arbitration clauses. But then again, the parties can ask the court for justified reasons to agree to relinquish its power of jurisdiction in order to be able to, for example, include other people or other entities in proceedings, especially in proceedings in complex patrimonial matters. Swiss courts will retain their power of jurisdiction, irrespective of forum more convenience and somewhere else, and irrespective a potential lack of recognition and enforcement of the Swiss judgment. And this is really something really worth noting. For example, if other countries will not recognize Swiss judgment because a religious court has exclusive power of jurisdiction to rule on the divorce, or because the judge of locus rei sete will want to have an exclusive power of jurisdiction on real estate. Well, irrespective of that, Swiss courts will retain their power of jurisdiction. Now, what are the law or the laws governing in Swiss divorce? It's always Swiss law. But Swiss courts will recognize the law governing the matrimonial regime that both parties can choose, even at the latest moment. They will also recognize marriage contracts governed by other foreign laws, and they will also recognize the law of foreign domicile, which will govern maintenance before divorce, and that's in case of interim relief orders. In Switzerland, we have one or two-step proceedings. One step, it's divorce immediately by consent, and you can do that anytime. But you really have to be aware of consent withdrawal. What do I mean by that? You can get a divorce in Switzerland provided you have lived separately for 2 years. Before that, you can only get a divorce by consent. And this consent, of course, can be withdrawn at the first hearing, and then you're going to have to litigate to lose your divorce case. So this is really something that needs to be carefully planned. You can also get your divorce for justified reasons. That's immediately, but this is really very difficult to get because it's really lengthy, and at the end of maybe 2 years proceedings, you're going to get your divorce, which you would have gotten anyway if you had waited for 2 years before initiating any proceedings. Or you can get, as I said, your divorce after 2 years of separate household, pending which you have measures for the protection of the marriage, and these are really contentious proceedings if you have no agreement. These proceedings are going to relate to the exclusive use of the family home and its furnishings and the car. They're going to relate to the care of children in common, child maintenance, and spousal support. And these are going to be bitter proceedings because the standard of living that should be granted to the person asking for spousal support should be the same as the one that was enjoyed during joint household. So, protection of the marriage also includes disclosure and maybe asset freezing of the spouse that endangers the other spouse's potential matrimonial claim in the liquidation of the matrimonial regime that's 2 years later. Now, if you resort to divorce by consent, you have to be aware of the fact that there is no international treaty relating to recognition and enforcement of consent awards. For obvious reasons, what is filed is an agreement, not a dispute. In order to be ratified by the judge, the agreement needs not to be obviously unfair. What does that mean? In Switzerland, the judge is going to investigate and is going to need to investigate all matters relating to children and all matters relating to pension plan sharing. For the rest, the judge is going to investigate on finances for adults only if he is or she is requested to do so. And if there is a divorce by consent and an agreement is being filed with the court will only look at the question of whether it is not obviously unfair. What is not obviously unfair? Swiss contract law governs divorce settlements to be incorporated into a judgment by consent. That means you have a duty to act loyally, you need to be of good faith, and good faith is presumed. However, it's not going to be protected if it is incompatible with attention required to circumstances, which is why in Switzerland the agreements have less formal requisites. You don't really need to have separate representation, you don't need a notarized agreement. You need to be a good faith. Swiss law provides for nullity of content that is contrary to morals or to Swiss public order or to personality rights, or that has an illegal content. For example, if the divorce settlement provides for a money laundering of tax fraud, obviously this agreement would have an illegal content and the agreement would be null. Now, valid agreements can be voided because of essential mistake, unfair use of parties' inexperience or dependence, duress, fraud, and they need to be voided within a one-year deadline. That means that when you file for a consent divorce, then you really need to have good agreements. You need to explain why the agreement is fair, so that, to facilitate the judge's discharging of his or her duties. If you go for a contentious divorce, then basically proceedings law provide for one conciliation hearing at which there is a possible transaction. And this is very interesting because if you have a family agreement that is being ratified by the judge in the frame of a consent divorce, you're not sure that it's going to be recognized and enforced abroad. Whereas if you file for a contentious divorce and then you settle, it's going to be easier to have your divorce recognized abroad. However, you have to plan very carefully to make sure that you have an agreement past the conciliation hearing, because otherwise you're going to enter into very lengthy and costly proceedings. 1 to 5 years, stingy legal aid, lack of means of the justice system are going to make your case lost. What are the peculiarities of these proceedings? Excluded topics are the cause of divorce, except if you've pleaded for justified reasons, concrete parental cooperation post-divorce, and enforcement of parental responsibility post-divorce, which is difficult because obviously you enter into a very contentious proceedings process, and at the same time you're supposed to agree on how you're going to cooperate after proceedings, which means that you'd better plan your proceedings to make sure that they can stop the quickest way possible. What are the often mistreating subjects? Well, obviously tax, commercial matters, tricky valuation aspects like when you have crypto, corporate structures, international corporate structures. Obviously, you have a civil judge who might not be qualified in those matters. Now, it's a two parties only proceedings. That is, contrary to other states. You cannot include stakeholders. And the problem is that you need the stakeholders usually to have your agreement or the judgment enforced. So what do? There is a duty to keep confidentiality. That is, there is no public hearings, and there is a lifting of certain duties to keep secrecy. That is, for example, disclosure can be asked from bankers, tax advisors. Illegal proofs can be admitted if they serve the truth. And then you revert to the duty to act with good faith in proceedings too. Having said that, how will you plan an efficient situation after you divorce? Obviously, you have to resort to effective and efficient planning. The best way is to plan the desirable future. Try to imagine what is going to be your situation in 5 years' time. Which family ties will you have? What is your life going to be like? And then, based on this future, you come back to the present and plan for the best case scenario and the worst case scenario as far as the outcomes are concerned. Based on that, examine the places of enforcement, that is, the territories of conflict. Examine the pros and cons of each jurisdiction. Plan ahead to make sure that you make the best use possible of those foreign jurisdictions. Take into account stakeholders, third parties, and imagine how to protect them and how to include them to make sure that in the end, whatever you have, if it's a consent divorce or an agreement or a judgment, is going to be recognized and enforced if enforceability is going to have to take place against those stakeholders. Look at ammunition. What is ammunition in divorce proceedings? It's proofs and means. Where are the proofs? Can we get them? Can we protect them? Who are the main witnesses? If they are the main stakeholders, then you have a problem. You really need to protect them. And think of how using the conflict to get there fast, that is, to get to the best outcome possible with negotiation and litigation at the same time. Like, in international conflicts, you also plan for diplomacy when war is raging. And last but not least, most importantly, organize your case management. Have agile teams internationally. Have an agenda. Have somebody in charge of the agenda. And have a look at costs and set milestones to make sure that you review your strategy at certain times based on the best outcomes and the best scenarios and the worst that's going to happen if you don't do so. That was all. Thank you for your attention.